I previously served on the Intel committee, so I do appreciate the value of Section 702 as a tool in protecting our national interests, security. But I have never voted in favor of authorizing or reauthorizing Section 702 because of civil liberties concerns, especially regarding U.S. persons inquiries. And as noted, these inquiries can be in the thousands, and U.S. Persons' communications can be opened up in that way. So the last time we considered this issue of the privacy rights of U.S. citizens, Senator Durbin and Lee offered what, to my mind, was a compelling compromise. And you can conduct, this was a compromise, you can conduct U.S. person inquiries and see if there are results. But if you want to view the contents of those results, you need a warrant. So you can look at the outside of an envelope, but if you're going to open up the envelope and look inside, you need a warrant. So there was previously the assertion that Fourth Amendment did not apply to these FISA queries, et cetera, but that blanket assertion is no longer the case because there is now the Eastern District of New York case. And so that leads me to my question of Ms. Gotin. Am I pronouncing your name?
That's right, Goitin.
Gotin. So I think that you share my concern that there should not be this blanket Fourth Amendment concern because of this decision. So can you explain what the district court concluded in the Eastern District of New York case?
Sure, and it's not just a single district court. It was actually a unanimous three-judge panel of the Second Circuit that held that a query is a separate Fourth Amendment event from the original collection. The government had made the argument there are no restrictions on lawfully collected information. The FISA court had accepted that. A handful of district courts, without a whole lot of analysis, sort of went with the FISA court's assessment. What the Second Circuit said is, no, there is often a restriction or restrictions that the Fourth Amendment place on lawfully collected property or information. One example was the Supreme Court's decision in Riley in 2014, when the Supreme Court held that a lawfully seized cell phone could not be searched. The contents couldn't be searched. It was initially seized without a warrant. It was a search incident to arrest. And that in order to actually search the contents, the government had to go back and get a warrant because the search was a separate and greater privacy intrusion under a different justification than the initial search. It did not base its decision on the fact that this was property that still belonged to the person who owned the cell phone. Similarly, when the government gets a warrant to seize a laptop to search for evidence of tax fraud, it's lawfully in possession of the laptop. It can only search for evidence of tax fraud. If it wants to search for evidence of another crime, it has to go back to the court and get another warrant. On remand, the way the district court put it was a search that relies on an initial warrant or exception to the warrant requirement is limited by its original justification, and to intrude further on lawfully acquired items requires new and independent approval. And that is certainly the case in Section 702. Very quickly, Adam Klein has said that this was all about property. And whose property, whether the information is the property of the person or the government. The Supreme Court did away with property-based distinctions in 1967.
Excuse me, I am running out of time.
Yes.
Every time the issue of requiring search warrants comes up, the Justice Department says everything would come to a screeching halt. Do you agree with that kind of a broad, we can't do it? It would just stymie their efforts to protect our country?
Not at all. There's no case in terms of how much of a burden it would be. As we discussed before, we're talking about, if the government's numbers are correct, we're talking about maybe a couple of hundred of warrants a year. And in terms of national security, as I mentioned before, there's been, I have much more to say about this, but I know we're running out of time. The Privacy and Civil Liberties Board looked at the evidence and said, among the few backdoor searches that were useful, these searches could have taken place even if a warrant with certain exceptions were required.
Thank you very much.
Senator